Good afternoon, guys. This is a little bit of an early show for us, but we got a special guest, and I asked him when he'd come on, and this is the time he's here, so we're going to do it. Welcome to the show. My name is Sean, also known as Potentially Criminal. I am a defense attorney out in the Cleveland, Ohio area, and joining us today is Uncivil Law, and we're going to be talking about the case of Martin v. United States. Now, I saw the comment already. What did I do? No, it's not me. I promise it's not me. But the case of Martin v. United States is the idea of the FBI raided the wrong house. And obviously you think, okay, well, they have to make it right. Well, they never did. So the Martin family sued the FBI and the U.S. government. The U.S. government said, yeah, we're not going to let you do that. And we'll talk a little bit more about that, but let's bring our guest on. We got Kurt from Uncivil Law. How you doing, Kurt?
Any day when we can discuss con law is a good day with me, baby. Supreme Court is my favorite court. Let's go.
Well, thanks for being here, Kurt. So the way this worked, and I don't know, I'm going to just fill in chat real quick. So the Martins sued in federal court, and they lost at federal court. They appealed up to the 11th Circuit, and what the Martins sued under was the Federal Tort Claims Act. Now, normally you can't sue the federal government. They have what's called sovereign immunity. And that goes back to the king. And you couldn't sue the king unless the king allowed you to sue him. Well, the Tort Claims Act was introduced right after World War II, and it allowed you to sue the government for intentional torts for certain things. You were not liable. They weren't liable for punitive damages, but you could sue them if you were the victim of an intentional tort. So, for example, if you're standing in your front yard and the mailman happens to run you over and decides to run you over, you can sue the federal government for that. Yes, purposefully. You can sue for that. If you're walking down the street and a Secret Service agent starts beating the crap out of you, you can sue for that. So there are limited things you could sue for. Now, there are exceptions to this. Military members can't do that. It's hard to sue for actions against the military. It's called the Ferris Doctrine. Mm-hmm. That's something that's been a long-standing thing there. But this mainly is about civilians suing the federal government. So by the time it got to the 11th Circuit, the 11th Circuit said, no, the supremacy clause is actually important here. Therefore, sovereign immunity reigns. You cannot use the Federal Tort Claims Act.
Which makes no sense to me.
Yeah, and then some of you might out there say that doesn't make any sense. That's what the 11th Circuit said to the Martin family.
Yeah.
Which means at this point, there's nothing else you can do. There's literally no way to hold them accountable. You can't sue them any other way. If you sue them in state court, it gets removed to federal court. And then, the federal court has to not do anything. So literally there was no way to challenge them. So they sought certiorari in front of the Supreme Court. And before we get too far, I do want to show this because it does show you guys the situation here. So this was the FBI, and this is where they raided. So the Martins lived here. They lived at 3765 Denville Trace Road. The house they were looking for was 3741 Landau Lane. And the houses look completely different. Yeah. They're not even on the same block. They're not next to each other. It's not 3741 and 3714. No, not even close. Not even close.
Some of the numbers are the same.
Yes, some number. Well, they're in the same neighborhood. Now, and we gotta give
the FBI credit where we can.
Yes. They didn't shoot anybody or anybody's dogs, so that was the other good thing.
It wasn't the ATF.
Well, the FBI shoots dogs too. So why do I bring this up, guys? I bring this up because it's important to know this wasn't like they were hitting apartments in some sort of, crack-ridden, hovel somewhere. This is out in the suburbs of Atlanta. Like, all these houses are nice. They got mowed lawns, landscaping. And their body cam footage, because there were local police assisting the FBI. And on the front of the Martins mailbox, blasted out on big old letters, you could see reflecting in the lights of the police cars, is the address. And the reason why I say reflecting, because they hit the house like at 5 o'clock in the morning when it was dark out. So there was no reason for this. The FBI showed up, they put guns in everyone's face, and then when they realized where they weren't at the right spot, they go, and then they just walked out the door and left. And they said, oh, here's our card, and then went to go hit the other house. So,
new house, who dis?
Yeah. Well, yes, and they say, "Oh, well, here's our card," and it's like, "Oh, will you help us fix it?" And they say no. Pat says, "Are the cops illiterate?" Yes, cops are very illiterate. Cops like to do what I call the John Coffey defense, and they just go, "We simple police folk, we's done know what do. We just kick in doors, shoot dog. We're simple folk. Yes, sir. Yes, sir. Yes, sir." But it's not just the FBI, guys. Routinely, local SWAT teams do this. It's not uncommon for the police to do this. And as it goes, they always just say, "Well, sorry, we're not going to do anything about it." And now it's funny because DoorDash doesn't mess up. The pizza delivery guy doesn't mess up. And I think it'd be funny, like, going forward, maybe before you execute a warrant, order a pizza to that house and follow the pizza guy because he'll show you where to go because he doesn't get it wrong. Yes, they can't even read Denny's menus. So there.
And if he does get it wrong, you can sue DoorDash.
Yeah.
But you can't sue the FBI, or can you? Which is what brings us to the case. Yeah, for me, this doesn't make any sense because, all right, I certainly appreciate that federal law is supreme over state law. That's fine. But they're suing under the Federal Tort Claim Act, which, as the name suggests, is a federal act.
Yes.
Which means that Congress passed it. So supremacy clause, supreme to who? This is the federal government. The federal government passed a law saying, at least under some circumstances, not necessarily all, but under some circumstances, you can sue us under state law. Like, okay. I mean, you didn't have to write that law, but you did. So,
yes.
So the 11th Circuit says it's invalid because of the supremacy clause, but the supremacy clause says that the laws Congress create are supreme and it's a federal law. So, and around we go, and I'm just confused again.
Yes, exactly. Exactly. Now, guys, this case was litigated by the Institute for Justice. They just had the oral arguments.
They do good work.
Yeah, guys, if you never heard of them, they are a nonprofit organization. They represent people who, like the Martin family here, they wouldn't have been able to afford this. This has been going on for 8 years now.
You can't afford a bow tie like that, man.
Nope. Well, nobody would be able to afford a lawsuit this long. But all the other cases they represent of people who are getting abused by the government, like they do all the stuff. You're like, wow, it sounds like they're doing what the ACLU used to do. Yeah, pretty much. And if you guys ever want to support them, you guys can go to ij.org and you can donate like however you want to. Like
I'd work for the Institute of Justice. They're good people.
Oh, you did? Oh, cool.
I know. I say I would.
Oh, you would? Oh,
yeah.
They're very good people. But if you guys ever want to support them, they are out there, and they would definitely want to be involved. They definitely would like your help. So that's how they do things. KJ says, B. Ivory Lamar work for them? No, they do not. No, it does not. And one other thing I wanted to show you guys before we got going, there was an amicus brief filed. And it was just to show you how serious of a thing this is. This is an amicus brief that was filed by members of Congress. You're like, okay, well, what does that actually mean? And that doesn't always happen. But this one here, when you get to the bottom, it tells you who the amicus briefs was done by and supported by. Well, you have like Ron Paul, you have Thomas Massey, you have Harriet Hageman. Then you have some other people like Ron Wyden. Okay, whatever. But there is bipartisan support for this issue that the government shouldn't be allowed to do this to people, and that the Federal Tort Claims Act exists for a reason. It should be employed and used in the right way. So, with that said, we are going to get started here now, guys. We have C-SPAN. They don't have all the heads pop up on screen for this case. It's a little frustrating. They don't. But we have closed captioning, and we can explain to you who's talking at certain points. But the government's arguments really are the most interesting part of this whole thing.
So, yeah, I love for the government to make this make sense.
Yes. All right, so here we go, guys. If you can't hear it, let me know. We'll turn up the volume or try to.
We will hear argument first this morning in case 24-362, Martin versus United States. Mr. Giacomo.
Mr. Chief Justice, and may it please the court. Congress amended the Federal Tort Claims Act in 19...
Real quick, guys, Patrick Giacomo is the Institute of Justice attorney. He's arguing on behalf of the Martins. So they're going first.
1974 to ensure a legal remedy for the intentional torts of federal police. The text of the law enforcement proviso is phrased affirmatively as a freestanding rule. With regard to acts or omissions of investigative or law enforcement officers of the United States government, the FTCA shall apply to any claim arising out of 6 intentional torts. The United States is therefore liable for these intentional torts when committed by FBI agents empowered by law to execute searches, seizures, and arrests. Petitioners bring the claims Congress expressly permitted, but the 11th Circuit held that sovereign immunity bars them. As a result, the court asked the parties to address 2 questions. First, whether the Supremacy Clause bars FTCA claims.
How could it possibly?
No, and the parties agree. As a federal statute, the FTCA is protected by federal supremacy.
This is the attorney for the Martin family. This is the attorney for the Martins talking, guys. We'll try to break it up when the justices pop on, but he's giving his opening statement.
Not restricted by it. Second, whether the discretionary function exception is categorically inapplicable to proviso claims. The answer is yes, for 2 distinct reasons. Read in harmony, the provisions cover different categories. Once a plaintiff satisfies Section 1346b(1) by alleging the elements of an intentional tort, the discretionary function exception does not apply because intentional torts require unlawfulness. There's no such thing as a discretionary intentional tort. Read in hostility, assuming interstatutory conflict, the text, informed by familiar canons of construction and this court's precedent, demonstrates that Congress gave the proviso's waiver of sovereign immunity the last word. The proviso is the clearest statement of liability in the entire FTCA. So the government's argument in this case and the 11th Circuit's holding below invite a simple question. If even proviso claims Congress amended the statute to affirmatively guarantee are barred by sovereign immunity, what is left of the Federal Tort Claims Act? I welcome the court's questions.
How broadly does the proviso extend?
This is Clarence Thomas.
Well, if this court reads the proviso in harmony with the discretionary function exception, it doesn't expand any more broadly than it needs to make sure that those 2 don't come into conflict. But if the court presumes that there is conflict, Your Honor, then it would supersede the other exceptions.
So in this case, how would it apply?
In this case, it would apply because the court would simply say the discretionary function exception doesn't apply to this category of claims. The law enforcement proviso does, and that's the end of the analysis for the second question presented.
So how
Can we pause for just a second?
statutory interpretation?
So I just want to lay out a little bit about what they're talking about. So there's 2 provisions here that are relevant. First, part of the Federal Tort Claim Act says you can't sue relating to a discretionary function, even if that discretion is abused. So you can't sue for that reason. And that's a more general provision. But then in a more specific provision, it says that you can sue law enforcement for 6 specifically provided intentional torts. And so one of the questions is, how do we understand these 2 provisions? Is there a conflict? And if so, how would you resolve it? Now, for me, there's a lot of ways to resolve this. One principle is the more specific overcomes the more general. So if you have more general language and more specific, the specific overcomes the general, because otherwise, why have the specificity? So if you understand, in general, you can't sue for discretionary functions, even assuming that these are discretionary functions, which probably they're not, because how can you have a discretionary tort? But even assuming they were, you can sue for these 6 specific reasons. So it's an exception to the rule, is the way I view it. And so that's clean enough for me.
I would agree with that assessment of what they're looking at here. And it's just how do we apply it and where does this fit? So Clarence Thomas is still talking, but we'll see what everybody else says very shortly.
How far a proviso like this applies?
Well, Your Honor, there are a number of statutory canons of construction, and I think the answer to this specific question here is we know that it extends beyond simply subsection H because Congress stated it as an affirmative freestanding rule as opposed to somehow being parasitic to the language before it in subsection H.
Well, wouldn't you expect it to be placed someplace other than in one subsection after a colon?
So I would say as a general rule, Your Honor, the answer would probably be yes. But the reason the answer is no here is because when Congress enacted the law enforcement proviso, it understood that the only barrier to liability for the United States was the intentional torts exception, meaning Congress's understanding of the discretionary function exception is the same as the one I'm articulating here today.
And you get that from what? The legislative history?
No, Your Honor, we get it directly from the language of the law enforcement proviso, but the legislative history, or at least the context in which this amendment was made, make very clear that our interpretation is the correct one.
But I guess I don't understand.
This is Justice Ketanji Brown Jackson, guys.
Why in absolutely every case you say the two are mutually exclusive. I mean, isn't there a possibility? I mean, I completely understand your view that on the facts of this case, given the origins of how the law enforcement proviso came into being, it was a wrong house raid scenario, just like the one that you are addressing here. I understand how you say that this should not be a situation in which the claims are barred. But does reaching that conclusion require us to say that there can never be a situation in which the discretionary function exception applies in the law enforcement context? That seems to be what you're saying. Those two are just totally separate. And I wonder whether the kinds of policy determinations that I thought the discretionary function was about could arise in some law enforcement circumstances, albeit perhaps not here.
So let me say a few things, and then maybe we can have a dialogue about how this would operate. But to answer your question, no, certainly the petitioners in this case do not need this broader rule to be articulated for us to win this case. This is the quintessential proviso case. This is the type of case that motivated Congress, as we know from all the news coverage and the language of the statute, to enact the proviso. But of course, we're offering this answer in response to the second question that the court granted here, which is asking categorically how these two things interact. But to get then to that question, it's simply the case that, as we can see from this court's precedent addressing the discretionary function exception and the broader intentional torts exception since 1946, there's been no overlap even between those categories. And so now we're moving into the space with intentional torts committed by law enforcement officers, where there simply can't be a situation where you're exercising the type of discretionary function that the exception in 2680A covers, where you're also somehow committing an intentional tort, because those intentional torts will all hinge on some portion of the elements or defenses being there's a lack of legal justification, there's no probable cause, or something along those lines.
So I don't think it was quite fair to say that everybody agrees on the first question. Amici doesn't agree on the first question. But putting that aside, because Amici could address Wynn, and I understand your argument on that first question, I believe it's that Wynn, which was the basis of this circuit's decision, was a case involving state law conflict with federal law. There's no conflict here because federal law is what makes the officers liable, correct?
That's correct, Your Honor.
So there can't be a sovereign immunity preemption of federal law itself.
That's correct, Your Honor.
All right, now going to the second.
Do you want me to pause it?
No, it's just like, yeah, how does that make sense? How can you have sovereign immunity?
Yes.
Or supremacy? How
Mhm.
can how can supremacy clause be a barrier to federal statute? That doesn't make any sense.
And guys, this is Sotomayor now talking.
Point. There are 12 exceptions besides the law enforcement exception at issue here. I don't think you quarrel with the proposition that if a police officer assaults someone in a foreign land, which is another proviso among those 12, that the intentional tort provision would not control, correct?
That's correct, Your Honor.
What you're asking us to do is to say 11 of the 12 other exceptions are still operative against the law enforcement proviso, but only this one, the discretionary one, is not. Is that your position?
Not quite, Your Honor.
Well, but that's what it sounds like to me, because if the other 12 are applicable, because the text itself of the law enforcement provision says that the provisions of this chapter and the chapter includes all 12 of the other exceptions, shall apply to any claim for a police officer's assault and battery.
Yes, so if I could clarify what I mean, Your Honor. As we articulate in the briefs, we have two separate paths and two different interpretive methods for how the court could address QP2. On the first path, which is the harmony approach, there is not any overlap between provision A and subprovision H. And so you don't need to get into what to do if there's a conflict. If the court, as the government asks, assumes that there's a conflict here, even though none was found below in the 11th Circuit, then our analysis would extend beyond the reach of subsection H. And to address your specific textual question about the language of Chapter 171, the government actually agrees with us at footnote 3 of its brief, where it says the appropriate natural reading of that means that the Chapter 171 other than Section 2680. And the reason why that's the case is because that same language appears in the preamble of Section 2680, and it also appears in subsection C and subsection H. And so to take the position that subsection 2680 would cancel itself out would require the court to read that language differently in the preamble than how it would read it in subsection C and H.
It does seem to me that what you're asking us to do is to answer the question we didn't grant cert on.
So
You're asking us to say that an intentional tort is never discretionary. As Justice Ketanji Jackson mentioned, I'm not quite sure that's true. The case involving the Secret Service agent who arrested someone who appeared to be threatening a protectee. Under state law, if that person was not engaged in conduct that directly appeared to be threatening, that might not be an intentional tort, a false arrest. And yet, I think there's enough measure of discretion of deciding when someone could be a threat to the president or to some other protectee that would fall within the discretionary.
So let me respond in a few ways, Your Honor. First was your note about the scope of the second question presented. So I would say that our arguments here fall squarely within that scope because, as we explained, to understand whether there's a categorical application of one provision to the other, of course, we need to know what the categories are to see if they overlap at all. And that's not some sort of word games from us. If you read the government's bio at pages 21 and 22, where they propose the language for what this court ultimately adopted as QP2, they follow on with the next sentence explaining that what's wrong with our position is that it mischaracterizes the scope of the discretionary function exception. And so that question is not only explicitly in the language of question presented
I'm not sure because there's a huge circuit split in a lot of judges talking about how to define that is the discretionary exception. Judge Bibas has a wonderful concurrence in which he says it's been read too broadly.
Yes.
I might be sympathetic to that argument, okay? But I don't know whether we should be answering it.
So I agree that the court shouldn't be answering that broader question. And to clarify, in our cert petition, we relied on Judge Bibas's articulation of there being 3 separate circuit splits. We offered a 4th as well. And the one articulated in Section 2A of our cert petition is the one we're talking about here, this question of whether the law enforcement proviso and the discretionary function exception interact, and if so, what happens? And this court, of course, granted on that narrower question, which now asks the court only to consider what to do with intentional torts and torts that are committed by law enforcement officers, as opposed to the entire sphere of negligent torts that would also potentially come into play.
So why wouldn't a perfectly sensible?
This is Gorsuch, right?
Mm-hmm.
Yeah, that's what I was thinking. So it's just Gorsuch here, chat.
Approach be to say you might lose on whether the proviso applies outside of H and send it back for further consideration of the discretionary function arguments that you've made before us, that Judge Bibas has raised, and that are the subject of I don't know how many circuit splits. Wouldn't that be a sensible course?
So the reason I would suggest that the court doesn't take that approach, Your Honor, is that that would effectively be the court overruling the Nguyen decision, but leaving in place all the other bad decisions like Shivers.
We would leave in place everything as we found it, to be sure. And I don't doubt that there's an interesting circuit split that might merit our attention sometime soon. But this is an awkward vehicle to address it, given that it really wasn't teed up for us that way because of the peculiar nature of circuit law below.
So I would say, Your Honor, as the government argued in its bio for asking this separately phrased question to be taken, it said this is actually the threshold question, not for QP2.
I understand that, but I think it thought a different version of it was the threshold question, and that is how far does the proviso extend? Does it extend beyond H?
Well, Your Honor,
I can understand how you'd read it differently, but I think that's what the government was asking us to decide.
Well, Your Honor, I would just point out again, at the bio at 21 and 22, they articulate this point, and they say that resolving this question of QP2 is threshold to QP1 because the 11th Circuit's articulation of the Supremacy Clause bar is effectively just an importation of what it understands the discretionary function exception to be. And so if this court were to only address QP1, it would essentially be resolving the question only for the 11th Circuit, but leaving all the other circuits.
Well, I would answer both QPs, I think, but I'm wondering whether saying the proviso doesn't extend beyond H, but leaving you to argue below that the discretionary function exception doesn't include unconstitutional acts, intentional torts. And that would be something you could argue below. Now, if I can just, you can respond to that, but before I let you go.
Okay.
Like
I'll be up here.
Well, I got a lot of friends who want to have their chance too.
That is a good thing if you can make them laugh. That never hurts. So
don't try to do it on purpose though.
No. It should be organic. You can't force this. No, you can't act your way through the Supreme Court or any court, So,
not
Mandy,
advised.
are you saying we can give it a brief explanation of what they're arguing about right now, or what specifically are you asking about?
I thought we kind of already did that at the beginning. So
Yeah.
What more we need to do here?
Yeah, I don't know. So, anyways, we'll keep going. If you want to post something up, Mandy, we'll take a look at it.
I'd also like you to address the government's suggestion that we shouldn't address the Supremacy Clause question because we don't need to in this case.
Okay,
your thoughts about that?
Sure. So the first question on why the court shouldn't simply say the answer is that there isn't a categorical situation for QP2 and send it back is that then we go back to the 11th Circuit where the case law is such that there is no constitutional exception even. And so you're sending the petitioners back down into the 11th Circuit, where even the government agrees that the 11th Circuit precedent, which will say it doesn't matter if the Constitution's been violated, you can still act with discretion, is wrong. And we'll be stuck there with the hope of perhaps getting en banc review of the 11th Circuit. And the government will have then short-circuited the Nguyen decision without having to confront the way that the discretionary function exception actually overlaps with the law enforcement proviso. Now, to answer the second question about why or whether this court should address QP1, of course it should address QP1. But the point that the government is trying to get the court to decide QP2 on its preferred new text of QP2, which is whether it extends to the other 12 subcategories, that just goes to show that these two things are basically the same. The Supremacy Clause bar of the 11th Circuit is just a dressed up version of the discretionary function exception as the 11th Circuit and many of the other circuits have too broadly understood. And so this court can simply address by citing to Gaubert, here's where we know the line comes for the edge of the discretionary function exception without getting into every nook and cranny to still say, even with that line, maybe the further line not fully defined, we know that intentional torts committed by law enforcement officers are not going to touch that form of discretion as Congress articulated in subsection A.
So would it be helpful to you that if we were to send it back on Justice Gorsuch's suggestion that we just address the categorical separation between the two, would it be helpful to say something about whether or not we are speaking to the scope or extent of the discretionary function exception? I mean, I understood your response to Justice Gorsuch to be that if you just say no categorical exclusion of discretionary function, it goes back and the 11th Circuit is going to say, fine, discretionary function applies, barred. And that your point is that even if there's no categorical preclusion, we still have to have a debate about the extent to which the discretionary function actually covers these situations, or the one that you've presented in this case.
That's correct. And I would even go a little bit further, Your Honor, and say, if the ultimate result is this court takes the government's selected approach and just does answer basically each QP with a one-word answer and send the case back down, then it will also implicitly be saying that the exact sort of case that Congress amended this act to allow is going to be doomed by the 11th Circuit's precedent, which inverts the Galbraith standard and says, unless something specifically tells you in federal law you can't do anything, you have open discretion to do it.
No, we wouldn't be saying that. All we would be saying is that we're deciding this particular case. I know you would like us to go quite far, but all we would be saying is that the proviso applies only to H, and the 11th Circuit's supremacy clause cases appear to be a workaround based on them trying to work around their prior determination that the proviso applies across the board. Now, that may not be good for you. I understand that, and that's why you're arguing what you're arguing. But as far as the development of our case law is concerned, why should we go further than that and get into this enormously complicated question about the scope of the discretionary function exception?
So, Your Honor, I wouldn't ask the court to get into the more enormously complicated aspects of the discretionary function exception. Again, we're simply saying there's a line where it's obviously not going to touch things like the law enforcement proviso. And the reason that this court should get into that question here is because, as you explained, the 11th Circuit's workaround for what to do with this is its supremacy clause bar. But many of the other circuits have created workarounds. They're just messier and built into a factual analysis of each case, where, for instance, all of the other cases except for Linder have held, well, of course, the discretionary function exception can't reach the sort of heartland law enforcement things, but maybe in this case, because it's an INS arrest or because it's something outside of what we perceive to be normal law enforcement, things are different. And so the line is being drawn right now by all the circuits. They're just confused about where to draw it. And because of that confusion, the line varies from circuit to circuit. And so if this court is going to take this issue up and provide any clarity, it should provide clarity to all of the circuits instead of just the 11th Circuit. And I think that's doubly important here because, again, Congress...
No, guys, what are they pointing out here? Congress already stated what we need to do. They already stated what we can do. We don't need to have all the circuits start coming up with their own conclusions. Congress explicitly stated what they were allowing to happen. And the reason why you see it was in 1974, guys, this was as a result of the war on drugs, and feds were basically kicking in whatever doors they wanted to, and there was no liability. They were heavily abusing their power in the war on drugs. It's almost like that's a reoccurring theme. But especially at the brand new part of the war on drugs, Congress was like, we can't allow this to keep going. So they did envision the feds abusing things. That's why they passed this. And I think it's good that he's pointing out we don't need all the circuits to weigh in. We already have the guidance from Congress.
Went out of its way in 1974 to go through all the steps it needed to go through to specifically amend the FTCA to say this very affirmative freestanding thing. If you're a federal law enforcement who commits an intentional tort, we, the United States, not you, the officer, will pay for it to make sure that there's a remedy for the innocent victims of your mistake or wrongdoing. And so it's more important than simply just answering a categorical question. There needs to be some guidance on this so that this statutory provision actually has effect. Because going back to Justice Jackson's discussion with me, the result in this case of the Martin family having no remedy here is that that provision has no effect. It's a complete nullity if that is the outcome of this case.
It does seem to me that we need to address the supremacy clause question, because if we were to send this case back on the narrow grounds we've been discussing with you and that you're resisting so well, it's possible that the 11th Circuit could wind up agreeing with you that the discretionary function exception doesn't reach your case. Perhaps that requires the en banc court's intervention, but it might do so. And then it would still have its supremacy clause jurisprudence that would bar your case. So at the very least, it seems to me that we need to address that. Do you see it differently? And what are your thoughts about that?
No, Your Honor. I think the court it should definitely address the supremacy clause bar as the 11th Circuit articulated it, because that bar, of course, as it's phrased as any actions that are within the nexus of federal officials' acts and within the furthest reaches of the Constitution are going to be provided supremacy clause protection, basically takes away most of, if not all of, the thrust of the FTCA, which of course is why my friend amicus on the other side has said, well, maybe we can just go back to private bills, which is, I think, the main mischief that Congress was intending to remedy with the FTCA, in the same way that the mischief that they were trying to remedy with the proviso are the very sort of intentional torts
Little
committed
pause
by
there.
the FBI agents in this.
They threw out a term that people might not be familiar with, the term private bill. So most bills that Congress pass are called public bills because they affect the public at large. Private bills are basically a bill that Congress passes basically to fix one guy's problem or a few select people's problems. So Congress was fixing some of these cases with police doing bad things by passing a bill that says specifically for you in particular, we're granting you this specific relief without doing it in general. And then Congress kind of got tired of that. Another scenario you sometimes see private bills is sometimes Congress grants citizenship to specifically named people to bypass the normal immigration procedure. It's something they can do because they have control of immigration. So sometimes you'll see it for that reason. And I'm sure there's some other examples, but those are the ones that come to the top of my head.
Well, Chet, an example of other private bills or things like that where the government will fix things for one specific people. I've covered this on my show before. Like under the National Firearms Act, there are specific weapons that are specifically exempted per serial number from different types of federal laws. So like people did get specific dispensations for certain things. So yes, it's not uncommon. We wish it didn't happen all the time, but it is out there. It is out there. So let's see here.
Sometimes when you need an act of Congress, sometimes Congress is like, okay.
Yeah, sometimes they're like, cool, here you go, buddy. Please put your name on it.
Case.
Justice Thomas, anything further? Justice Alito? Justice Kagan? Justice Kavanaugh? Justice Jackson? Thank you, counsel.
Thank you, Your Honor.
Now, I will say, when everybody's like, nope, I'm good. Sometimes that can be good. Sometimes that can be bad.
It's a little freaky.
Yeah, but it's going to be the second part of this that tells you, like, this is actually okay. So here we go. Here comes the government arguing on behalf of the DOJ.
Mr. Liu?
Mr. Chief Justice, and may it please the court. This court granted cert on two questions, one about the reach of the proviso in subsection H, and the other about the supremacy clause. To resolve this case, this court need only decide the question about the proviso, namely, whether the proviso in subsection H modifies the discretionary function exception in subsection A. The answer is no. Congress placed the proviso in subsection H, and given that choice, the proviso modifies only subsection H. It does not modify the discretionary function exception in A. That exception, therefore, bars petitioner's claims. And because it does, this court need not reach the other question presented, which asks whether the supremacy clause bars those claims. The 11th Circuit resorted to the supremacy clause only because under circuit precedent, the proviso in H modifies the discretionary function exception in A and renders that exception inapplicable. But if this court rejects that interpretation of the proviso, it should simply affirm on the ground that the discretionary function exception bars petitioner's claims without reaching the supremacy clause issue. Now, petitioners have injected a third issue into the case, whether their claims satisfy the discretionary function exception in the first place. In other words, whether they satisfy the two-part test this court articulated in United States versus Gobert. But that issue isn't fairly encompassed by the questions presented, and it's not independently cert-worthy. In any event, if this court does reach the issue, all they would need to do is reaffirm Gobert, because petitioner's claims clearly satisfy Gobert's test. I welcome the court's questions.
Sounds like some bullshit to me.
Can a proviso?
Oh, hold on, Kurt. What's that?
So it sounds like some bullshit to me.
Yes. Oh, it is.
Extend more broadly than this case?
So the presumption is a proviso applies only to the thing that it's attached to, but there are cases where the court has found that presumption rebutted and has thus read a proviso to state a general freestanding rule. We don't think there's any indication here, any basis for finding the presumption that the proviso applies only to the thing it's attached to be rebutted. And so we think the general principle that a proviso applies only to the thing it's attached survives and applies here.
Well, I mean, your approach puts a lot of weight on strict adherence by draftsmen in Congress to organization along that lines. It's certainly plausible that H was the main thing that the proviso was addressed to, but not necessarily the only thing.
Yeah, I don't really think that's plausible. I mean, put yourself in the shoes of the 1974 Congress. It had before it all of Section 2680, the lead-in language, plus 13 exceptions, starting with A, ending with N. And if Congress had wanted to create a universally applicable proviso, i.e. one that applied to all 13 exceptions, I don't think they would have put it in the middle in H.
No, that's the most logical place to put it, but it's a heroic assumption to think back to 1974 and put myself in Congress's shoes. But it's also, you know, they got a lot of things going on. They're very busy. And if it applies logically more generally, I don't know why we wouldn't at least entertain that.
Well, I don't think it applies logically more generally. All the textual and structural indications indicate that Congress put it in H because it wanted to apply in H. And so it's not just that it's in H, it's also that
I would love
Congress
to,
used
Sean, I would love to know from her point of view, what exactly is left if she's right? If this proviso only applies to H,
yeah.
And so what exactly is left? Under what circumstances would I be able to sue? I don't know the answer to that question. Are there any other circumstances?
No, there really wouldn't be. Like, that's the thing.
You would have to have a non-discretionary intentional act. But a lot of what the exec does is discretionary. Almost all of it's discretionary.
Yeah.
So what is the exec required to do? That I don't know what that would even be. That's not much left, man. And if they are required to do, if they are actually like required to do it for some reason, it'd be really weird for them to say, on the one hand, we're required to do it, and the other hand, we're going to hold ourselves liable for the thing that we're actually forced to do. So we actually have no opportunity to even avoid the harm, which goes against standard analysis too. Because like if you say to me, like, I'm going to fine you, I want to know, how am I not going to get fined? Right? It's like trespassing is bad. What do I have to do to not get to not trespass? Well, don't enter my land. Great. It's like, but I have to enter your land for some reason. I have to. But you're also going to be able to sue me. This is because I made myself liable. I chose to make myself liable. How does this make any sense? I don't get it. It's stupid. It's dumb. I don't like it.
Hey, chat, this is what they're talking about, Part H here. Any claim arising out of assault, battery, false imprisonment, false arrest, malicious prosecution, abuse of process, libel, slander, misrepresentation, deceit, or interference with contract rights. And these are the things that would happen here. And this is where, if it happens in a foreign country, you're toast. Any claim arising from the activities of the Tennessee Valley Authority. Any claim arising from the activities of the Panama Canal Company, which really isn't a thing we have to worry about anymore, at least for now.
Are you sure?
Well, for now, put a pin in that one. Any claim arising from the activities of a federal land bank. Now, if you guys don't know what a land bank is, a land bank gives out land to people. It's actually not as much of the feds anymore, but if you live in a city, you probably do have a local land bank. They generally take over vacant houses, demolish them, and then sell out the vacant lots to people. A federal intermediate credit bank or a bank for cooperatives. You know, these are things that you are... these are the exceptions to it. So that is what they're talking about. The TVA's got to go.
What did they ever do to you?
Yeah. Well, they're not going anywhere. They're not going anywhere.
That phrase "provided that," which is words Congress uses when it wants to introduce a proviso, which then triggers this presumption that it applies only to the thing it's attached. It's the fact that Congress before the provided that used the colon, which suggests that
Not the colon. I love it. It's coming down to which punctuation mark we use. That's fun.
Yes. Well, that's the thing. When you're having to fight like that, you're saying, well, actually, Judge. No, you're toast. You know. Well, you see, Congress put a period here, and that's what that means. It's like when you're arguing that way, you're very much in trouble.
period after the proviso, which then separates the proviso from every other exception in the statute. It's the fact that even my friend concedes that it would be implausible for Congress to have wanted the proviso to apply to certain exceptions, especially subsection K, which is the foreign country exception. No one thought Congress wanted to open the door to the application of substantive foreign law in cases involving police conduct. It's the idea that there's a similar parallel proviso or exception in subsection C, and no one thinks that exception applies to all the other exceptions. I think everyone agrees that that exception applies only to subsection C. And so I think you have all the relevant text.
Counsel, what was Congress doing? It
That's a good question.
this proviso because of the Collinsville.
What's that, Kurt?
I was like, that's a good question. What was Congress doing?
Yeah,
What is Congress doing? That's a good question.
Yes. Well, Congress already acted. They set this shit up.
Raids. Their officers, without a warrant, broke into a home. They tied up people. They were as threatening as in the current situation. Why bother if we accept that they had the discretion to think there was danger? With or without a warrant, the emergency doctrine exception would let them break down a door. So what was Congress thinking?
So I don't think that the conduct in the Collinsville raids falls within the discretionary function exception.
But why? Only because there was no warrant?
Because their conduct was well beyond the discretion conferred on them because it violated clearly established amendment
That's
rights.
interesting because in Garber, we said, if an official drove an automobile on a
Yeah.
When they say that's interesting in that tone, that's code for that's bullshit.
Yeah. So here we go. And we'll play that a little bit there again, guys, so you guys can really take it in.
the doctrine exception would let them break down a door. So what was Congress thinking?
So I don't think that the conduct in the Collinsville raids falls within the discretionary function exception.
But why? Only because there was no warrant?
Because their conduct was well beyond the discretion conferred on them because it violated clearly established amendment
That's
rights.
interesting because in Garber, we said, if an official drove an automobile on a mission connected with his official duties and negligently collided with another car, the exception, discretionary exception, would not apply. That was because, and I'm quoting, although driving requires the constant exercise of discretion, the official's decision in exercising that discretion negligently, I'm putting in that word, can hardly be said to be grounded in regulatory policy. I mean, I don't see the difference between that and saying that an officer's action in using a GPS to break into the wrong house has any policy related to it. It's like driving negligently. You got to that house by mistake.
Yeah.
You drove negligently and hit someone. So I don't understand how the act of going into a wrong house can be discretionary.
Well, we understand the discretion here to be the discretion as to how to identify the.
That I love that answer. It's like, oh.
No, I mean, the Supreme Court and judges in general are not usually like that clear about which way they're voting. I mean, usually you can tease it out. They're usually a little bit more subtle, but that was judicial speak for I hate you and everything you stand for.
Yes,
there's no chance in this world I'm going to rule for you.
Yes, I absolutely hate this
argument. And you're dumb.
Yes.
The target of a search warrant.
Oh, he had it identified. He got the right target. He just had the wrong house. It's not a question of, did he make a mistake in his warrant application about this individual being a drug dealer? All right, there I might agree with you. Okay, I'm talking about a wrong house raid. He has the right target, the right house, but breaks into the wrong one.
Right, and it's because, as the courts below found, of a reasonable mistake that the officer
That's
made.
the issue. Is that consistent with Gobert? And I'm asking you to explain to me how that formulation is consistent with Gobert.
Well, I would just run the conduct here through Gobert's two-part test. So step one of the test asks whether there is a federal law or statute or regulation that specifically prescribes a course of action that the employee needs to follow.
There is. Go get a search warrant for a drug dealer's house. Now, what policy says, now go search a house that's not the drug dealer?
Well, no policy says that.
And that is,
I love how she says that. I mean, you go look for everybody's houses.
Yeah, I think there's a policy against that. I seem to remember reading that.
Does that make it non-discretionary? Does that make it
I
discretionary?
think it was called the Fourth Amendment.
Yeah. I love. Oh, this is just beautiful. This is beautiful.
house. Now, what policy says, now go search a house that's not the drug dealer?
No, this is not about qualified immunity, doctor. What that actually qualified immunity, like if we get back to, if the Supreme Court says, wait, they can do this and you could sue them, and then it goes back to the trial court, the FBI will raise qualified immunity and say, sorry, we're protected. But no, we're not even, that's the second or the third door. The first door is, can we even get into the building and try the lawsuit? So we're at step one of even, can we legally file a lawsuit right now? Qualified immunity is a couple steps down the road, but yes, that's eventually what will happen. So,
yep.
Hillcourt is saying, can you clarify for us who got here late, was the wrong house entered due to an investigatory error or an administrative error? Sheer retardation. They didn't bother to look at the numbers. They didn't even bother to check where they were. So they knew where they were supposed to go, and they thought this was the house.
Their inability to read the number on the mailbox.
Yes, they couldn't read the numbers, and they couldn't tell the picture of the house apart. Like, they are two distinct houses, 500 feet apart. Not even on the same street.
The stupid.
So, yes, it's not an investigatory error or an administrative error. It's an autistic error. Very highly retarded.
Well, no policy says that.
And that is negligent driving.
No policy says don't break down the wrong house, the door of a house.
No, I excuse me. Of course, it's
The judge is like, wait, you telling me we have to tell you there's a policy of don't fucking do illegal things? But that's actually very funny because that's qualified immunity in a nutshell. You didn't say we couldn't do that. We didn't know that was illegal.
If they want to rule against qualified immunities while they're at it, that's fine by me too.
Yeah, I know, but that's for those of you out there wondering, how would you make a qualified immunity argument? You'd say, well, you didn't say we couldn't do this.
Yep.
You didn't tell us this.
It wasn't clearly established.
Yeah, there's no clear established rights if we do this. We didn't know that was wrong. And listen to Gorsuch. She's like, no. Now, if you guys notice, Barrett and Kavanaugh didn't say a word on the first part of the argument. So I wonder if they're going to pop up in here. But you notice a lot of people, not everyone spoke. So listen to Gorsuch again. This is getting good.
Is negligent driving.
No policy says don't break down the wrong house, the door of a house.
no. I excuse me. Of course, it's
Don't traumatize its occupants. Really?
Of course, it's the United States policy to execute the warrants at the right house.
I should hope so.
But stating the policy at that high level of generality doesn't foreclose or prescribe any particular course of action and how an officer goes about in identifying the right house. And as the district court found at 52A,
Did you
the
use your
sort of
eye
discretion
parts?
left to the officers here to determine the right house is filled with policy considerations.
Discretion to determine the right
officers
house.
here
Lol.
were weighing public safety considerations, efficiency
You
considerations.
could just read the warrant. It's
operational
literally in the
security,
warrant.
The idea that they
Yes.
didn't want to delay the start of the execution of the warrants because they wanted to execute all the warrants simultaneously. Those are precisely the sorts of policy trade-offs that an officer makes in determining, well, should I take one more extra precaution to make sure I'm at the right house? Here, petitioners suggest, for example, that the officer should have checked the house number.
Yeah, you might
on the
look at the
mailbox.
address of the house before you knock down the door.
Oh,
That might be a good one.
oh no, chat. When the Supreme Court Justice, notice he says, well, as the district court found, no, the district court's daddy just told you should probably check the address. Like, it doesn't matter what the district court says when their Daddy Neil, is like, no, you should probably read what you're doing.
Literally read the warrant. It tells you,
Yes.
it describes the property.
Yes. And then you take the number and you go, huh, one of these is not like the other. So, but yes, I love that. Is beautiful.
Public safety considerations, efficiency considerations, operational security, the idea that they didn't want to delay the start of the execution of the warrants because they wanted to execute all the warrants simultaneously. Those are precisely the sorts of policy trade-offs that an officer makes in determining, well, should I take one more extra precaution to make sure I'm at the right house? Here, petitioners suggest, for example, that the officer should have checked the house number.
Yeah, you might
on the
look at the
mailbox.
address of the house before you knock down the door.
Yes, and as the
Oh.
district court found at 52A, that sort of decision is filled with policy trade-offs because checking the house number at the end of the
Really?
driveway means exposing the agents to potential lines of fire.
How about
from
making sure
windows.
you're
Oh, you know what? Too fucking bad. You've got body armor. You've got a helmet on. You've got a fully automatic M4. Guess what? You have the why do you have those? Because the bad guys might shoot you. But it's like, oh well, that's why you have all that shit. You know, and you get to call on the radio and all your friends show up with guns. And you get to shoot at that bad guy. Like, you know, fucking suffer, Fed boys. Suffer. You know, I love this. So Gort's just like, how about making sure you're on the right street?
Decision is filled with policy trade-offs because checking the
Really?
house number at the end of the driveway means exposing the agents to potential lines of fire.
How about
from
making sure
windows.
you're on the right street? Is that?
And how does that
I mean,
read?
just
The silence. That guy wasn't ready. Oh, you can hear him pouring water. Uh-oh. I'm dead.
This isn't going well for our friends at the DOJ, I don't think.
No. And
No.
who is this coming in right now with him?
I don't know.
Okay.
I couldn't hear the voice.
At the end of the driveway means exposing the agents to potential lines of fire.
how about
from
making sure
windows.
you're on the right street?
Crickets.
Is that?
And how does that
I mean,
read?
just the right
Oh, that's
street.
Jackson again.
No, I mean, I was just going
Checking the
to say,
street sign. Is that
Getting hit from the right, hit from the
asking too
left,
much?
hit every way.
what I would say is exactly what the courts below found, which is that the officers here made a reasonable mistake as to where they were. The allegation from petitioners' claims is that they should have done more. They should have stopped and got out of the caravan of vehicles and checked the streets.
But I guess,
They should have-
Mr. Liu, the question is, how does that really differ from Colesville? I mean, the problem that I think is sort of what is happening in your analysis is that you say that the Colesville conduct does not fall within the discretionary function exception, which seems to me to be a concession that even if we agree with you that these aren't in two separate categories, law enforcement and discretionary function, we still have to figure out how broad the discretionary function exception is,
Yeah.
which is the question you say we're not allowed to answer.
The conduct in Collinsville
Not
flunks
allowed
the
to
first
answer.
step
Yeah.
of the Gaubert two-part test. The
Is that
Don't-
the discretionary
Don't
function
tell the
test?
Supreme Court what
Yes.
they
All
are
right,
or
well,
are
so
not
then
allowed
we
to
are
decide.
having to assess the scope of the discretionary function in this conduct and in this context.
I don't
see
think
how
so.
I don't see how you can say we have separated that out of the question presented. We can't look at it, and you're still answering these questions in this way.
No, because I think this case comes to the court on the assumption, as the courts below found at 17 to 18A and at 58A, that the conduct here did satisfy Gaubert's two-part test. Now, the only out that petitioners have left then is to say that the proviso nevertheless removes those claims from the scope of A. That's what I took to be the threshold statutory question that this court granted cert to decide. If I may just address one point that my friend
I'm
raised.
sorry, counsel. You're
No, you
doing
can't.
exactly what
May I
the other
discuss
side is
something?
doing.
No.
You are
Absolutely
begging the
not.
question,
Yes.
which is how far is the discretionary exception goes. The other side wants an absolute rule that all intentional torts are not covered. You want the opposite, which is if there's any discretion in the activity, then no negligences or intentional actions are covered.
No, I
The
don't.
two of you are going into separate corners.
I'm not asking for an absolute rule. I'm asking for the court to just stick with its test in Gaubert.
Yes, because you got a great decision below, but is that fair?
It sometimes that test will result in the United States being exposed to liability. Sometimes it won't. It's not an absolute test. If I may just address my friend's suggestion that the proviso did nothing when Congress enacted it, we don't view that to be the case. Before the proviso was enacted, officers like Guerra had two layers of protection from liability. They had the discretionary function exception, and then they had an extra special layer of protection provided by subsection H, which gave the United States blanket immunity for any claim based on a particular type of tort. What the proviso did was remove that special layer of protection, but it left in place.
That is so ridiculous. Congress is looking at the Collins.
Oh my God. Oh my God. You don't hear that kind of language from the Supreme Court? Holy
No, you don't.
shit. Oh
No.
my God.
That
Oh, this is brutal. This is brutal.
yeah. This
Oh.
guys, this is
Oh my God. Someone give that woman a cigarette. She's toast.
yeah, this is this is not good. This is not good. You know what? I mean, we're not in a good spot if you're the DOJ, but
No,
is this going to be an 8-1 or 9-0? I don't know.
I want to crawl into a hole and die.
Yes.
Oh,
Or
man.
as Johnny Osprey said over in your chat, oh no, here comes the ghost of Justice Holmes with a chair. My God. Yes, it's coming out of nowhere.
Something like
out
that.
of nowhere. So
Wouldn't be how I phrase it, but sure.
yes, this is not ending well, chat.
Denville raid and providing a remedy to people who have been wrongfully raided. And you're now saying, no, they really didn't want to protect them fully. They were just going to take them out of that exception, but leave in the discretionary exception. I gave you discretion in Collinsville. The officers are permitted to break into a home if they think an emergency existed. That's why those officers did that.
Yeah,
They may have been wrong about the emergency existing. They may have been wrong about the warrant law, but under your test, it's their discretion to arrest when they think there's an emergency.
No, what we understand the proviso to do is to remove that blanket special layer of protection in H. That requires the U.S. in these types of cases to battle it out under the discretionary function exception. And that's quite significant because there's a large set of cases that are going to flunk this court's two-part test in Gaubert, chief among them the raids in Collinsville. And so by removing the proviso.
That's right, flunk it. All right, thank you.
So by removing the proviso, it requires the United States to hash it out under the discretionary function exception. As I say, there are plenty of cases that are going to fall outside that discretionary function exception.
Thank you, counsel. Is there anything else you wanted to add to that point?
No, thank you.
Justice Thomas?
Anything you want to add?
Justice Lujan?
Once again, guys, Barrett and Kavanaugh are really quiet again. Justice Kagan was quiet. Even this time around, Alito didn't say much. This is
Oh my god.
This is not a good one. If you're like this, some of you guys are like, oh, that sounded bad for the Institute of Justice guy. No, this went really bad for the DOJ now. You can see.
Oh no, this is Justice was great. I mean,
Yeah,
it's
I know,
a love
but
fest by comparison, damn.
When you look at like how nobody's responding to the arguments, although all the judges are sitting there, I'm like, this is the nerdiest shit ever. I don't want to deal with this. Why can't it just be something fun?
This is pretty fun, man.
Yes,
it's pretty fun. This is just we need to get Joe Rogan to do commentary for this fight. Holy shit!
Yes. Oh no, that was when one of the Supreme Court just says you are being ridiculous. I don't know how much better or how much worse it can get, other than you getting escorted out.
Just so I'm clear, we can say the supremacy clause is.
Well, here's Kavanaugh.
I know you don't want us to reach that, but we can say that. We can say the proviso does not apply beyond H, and we can stop there and leave questions about how to apply the discretionary function exception to the facts of this case for remand. Correct?
That's right. I would say that the courts below already did that analysis, and so a remand.
But if so, they can say that.
They can say that again on remand.
Thank you.
Thanks.
Justice Barrett? Justice Jackson?
Can I just, before you
little
leave the
bit
podium,
of branch of hope.
Can I just ask you about your point that we should not reach the supremacy clause question? I guess I have a concern about our jurisdiction in this particular set of situation, because I'm looking at 28 USC 1254, which outlines our certiorari jurisdiction. It allows us to hear appeals from lower courts by writ of certiorari granted upon the petition of any party. And the only question that we're looking at now that was put to us by petition is the supremacy clause question. The government, in this case, asked us in the bio to add what we now call the second question. Mm-hmm. And so I guess I don't understand that, I appreciate that we could also hear that question, but I'm a little worried about suggesting that we can exercise jurisdiction to resolve a question that never appeared, only a question that never appeared in any cert petition before us.
Yeah, I don't think that's quite right. I understand the granting of the petition to be necessary for this court to exercise its power, but that once it's granted the petition,
then we can totally change it and add questions that don't exist.
I do think
it wouldn't be the first time.
This court's discretion at that point to decide, for reasons of prudence or otherwise, exactly what questions it wishes to decide in reviewing the judgment below, because that's ultimately what's being reviewed as the judgment.
Okay.
Yeah, it wouldn't be the first time.
Thank
It's
you,
unusual, but it's happened before.
Mr. Mills?
Mr. Chief Justice, and may it please the court. The FTCA does not make the United States liable for lawful acts of its agents. That is true for three reasons. First, Section 2674 makes the government liable only to the same extent as a private person in like circumstances under state law, and a private person cannot face state liability that conflicts with federal law. Second, Section 2674 reserves any other defenses, including those only available to government agents. Government agents are not liable for acts within their federal duties. Third, a federal court in an FTCA case stands in state court shoes, which means it must consider applicable federal law. Otherwise, the United States would be liable where a private person and a government agent would not, contradicting the statute. Thus, the United States can have a supremacy clause defense in FTCA cases. I welcome the court's questions.
I don't quite understand your argument.
Who's this arguing now?
I think you suggest that.
I don't know actually. Hold on. Who is arguing? I'll take a look here. It's not
this is a court appointed amici in support of judgment below in question one. So the court appointed their own advocate to answer argue part of the question,
which they do once in a while. They're a court. They can do whatever they want. So we'll see.
Which means that not even the U.S. government wanted to defend.
Yes,
that's what that means. The U.S. government. So what happened here is that the court below reached a decision. let me just clarify it. The court below reached a decision, and not even the U.S. government wants to defend all that decision. Okay, that's how bad it is. That they don't want to do it. So basically, what happens? One of the things that happens is the Supreme Court will then appoint someone, be like, guess what? You're going to argue for the position of the court below, which not even the U.S. government wants a piece of. Make it work. So, good luck with that plan. It's like, well, I'm doomed to fail, but, I'll give it a shot.
It's even worse than devil's advocate. You're literally getting your ass kicked on this one. So, Paul Clement got one of those in the Eric Adams case. He had to argue what he thought the proper thing was to resolve that case. So that does happen. It does happen sometimes.
Yeah.
You can raise sovereign immunity as a defense, a private individual.
No, Your Honor. My argument is that a private individual can raise the supremacy clause as a defense to state tort liability.
Okay.
And they have in this court's case law. So Hunter versus Wood involves the government, this court giving a supremacy clause defense to a private railroad ticket agent who was following federal law.
Do you think that a private individual can enforce federal law?
Yes, Your Honor. So I think Hunter is a perfect example of that. There, the railroad agent was following a federal court order. Here you have something similar with the agents following the warrant. You also have that sort of flavor in other cases. For example, when an airline denies boarding to someone who under FAA regulations doesn't show the proper ID, that's another example of a federal law duty.
Why do you think the 11th Circuit took this tack of sovereign immunity?
Yes, chat, this is Clarence Thomas talking.
So I don't dispute the party's contention.
He has no
that
idea.
There seems to be a concern based on the 11th Circuit precedent.
Oh my God!
And its interpretation of the intentional tort proviso.
Pause.
But
go for it.
I don't think you guys appreciate what just happened. Okay, this guy has been appointed specifically for the purpose of defending the decision below. That is his mission in life. He has been given the assignment: defend the decision below. And Clarence Thomas asked him, why do you think the 11th Circuit did this? And even though it's literally his job to defend the decision below, he just said, I don't know.
Mm-hmm. Well, I read the 11th Circuit thing. I don't know either.
I've been tasked specifically with using all my legal power and all my legal power. And I was appointed by you, incidentally, the Supreme Court. So I'm probably pretty good at this, right? Because you guys specifically put me in as a pinch hitter. And like, hey, can even you defend this bullshit? And I got nothing. That answer was so cringe-inducing. I want to die.
Yes. And chat, they don't just go down the list of all the attorneys in the Supreme Court. They have special ones like, oh, he's good. This is good for him. And we'll pay him for it.
Is he being punished?
Yeah. Did he run up? Did
he do something wrong?
He hit Gorsuch's dog or something, probably. But anyways, here we go, guys. We're gonna back up for that.
Yeah.
Notice the examples we're having to go to.
Listen to this question and answer. Listen to it again. Listen. The question is, why does this make sense? And the answer is, I got nothing. Listen again.
And they're getting to the point of, well, what if it's a ticket agent denying you on a plane? Well, that's not at all like this. This is completely different. But anyways, we'll go back here.
Court giving a supremacy clause defense to a private railroad ticket agent who was following federal law.
Do you think that a private individual can enforce federal law?
Yes, Your Honor. So I think Hunter is a perfect example of that. There, the railroad agent was following a federal court order. Here you have something similar with the agents following the warrant. You also have that sort of flavor in other cases. For example, when an airline denies boarding to someone who under FAA regulations doesn't show the proper ID, that's another example of a federal law duty.
Why do you think the 11th Circuit took this tack of sovereign immunity?
So I don't dispute the party's contention that there seems to be a concern based on the 11th Circuit precedent, and its interpretation of the intentional tort proviso. But more importantly, I think the 11th Circuit was right. I think their position follows from Section 2674.
Oh, that's conclusory. That's great. I don't know why, but they're right because it's right. That's great. It's conclusory. Well, the 11th Circuit's right because it flows from the text. Oh, okay. Thanks for the circular reasoning. That's fantastic. Bullshit.
He's got to say something, and if he just goes up, he probably realizes, like, okay, if I do a bad job, they're never going to let me do this again. And I bet that pays pretty good. Like, he gets the bill pretty decently for that as an attorney because he's not doing it for free. But I do think he has to go up there. He can't just go up there and say, well, Judge, I think they're fucking retards down in Gainesville. Or I think it's Atlanta where the 11th Circuit is. I think they're a bunch of fucking retards. You can't do that. You can't do that argument. It won't go well.
Oh, this is painful.
Yeah, it is. It is.
Mr. Mills, I mean, you're quite right, of course, that private parties can raise
We're back to
preemption,
Sotomayor now, chat.
Arguments, and that the United States could raise the same sort of preemption arguments. But I guess the question that I have is, how is that really relevant to this case? Because that's not the nature of the immunity defense that the 11th Circuit applied here. It wasn't a statutory preemption sort of argument. It was a basic sovereign immunity kind of argument.
I disagree, Your Honor. I think it was a standard preemption analysis, just like this court's decision in Neagle. And so I think Neagle is a prong of this court's statutory preemption analysis that obviously comes up more rarely than the typical preemption cases, but it involves the exact same conflict between federal law says you must do this and state law says you can't take this action reasonably necessary to do that. So I think that you do have the same implied conflict that you would in other statutory preemption cases. And I think the private person, the key there is that it's in like circumstances. So, as an example, I would point the court to 28 U.S.C. 530B, which says federal government attorneys are subject to state rules of professional conduct, quote, to the same extent as other attorneys in that state. And the lower courts and the federal government have read that.
I mean, let me just cite some other completely random part of law. I'd like to talk to you about the finer points of the Copyright Act. What the fuck are we doing? What? Did he lose his place? Did he have a stroke?
I don't know. I think he's struggling here. He's trying. So.
Language, look at their bio in 161323 to mean that a preemption defense is available even though the federal statute references or incorporates the state rules. The government says no attorney can be subject to a state rule that conflicts with federal law, and because government attorneys are subject to them only to the same extent, therefore neither can the government attorneys. And that's the exact same point I'm making here. No private person can face state liability that conflicts with and thus is preempted by federal law. And so within the scope of 2674, neither can the United States. But even if you set aside the private individual aspect, you still have the third paragraph in section 2674, which provides any other defenses, including defenses available to government agents. On the petitioner's theory, Neagle, in the famous case where he protected Justice Field, escapes liability because he had a federal duty. But on the petitioner's theory, today he could turn Mrs. Terry, the wife of the assailant, could turn around and sue the United States for damages, and the United States would be civilly liable, even though Neagle was performing his federal duties. Same thing in this case. If the agents had gone to the right house under their theory, and state tort liability would have applied under whatever the state law happens to be, the United States would be civilly liable for money damage.
How is so their argument is, well, wait, the bad guys could sue us. No, you can't do that. That never happens anywhere. If they went to the right house, the bad guys might sue me. No, they're never allowed to sue you.
For what?
They'll sue you for the intentional torts. You caused me harm. You broke down my door. You ruined my property. I just, that is so, It's such
Yeah,
a smooth
but-
brain
but
fucking
we had-
argument,
but
even
we
when
had
you're
per-
forced to
but-
deal with it.
If we were going to do it under analysis of a tort analysis, I'd be like, they had permission because they had the warrant. Warrant is literally permission.
Yeah.
So they broke into your house. Yeah, but they had permission.
Yes.
So that defeats the claim of trespass.
Mhm.
So, okay, moving on to the next thing.
Yes. It's just, this is so damn funny. Oh, hitting the wrong screen.
Damages for going to the right house. So I think that underscores that there has to be a supremacy clause defense available when the federal agent was acting within their federal duties. And then the last aspect I would point to is this court's decisions in Richards and Hess, where the court said you have to consider applicable federal law. Again, the court said that's the only way to make sure that the statute doesn't extend more liability to the United States than that faced by private individuals or the government agents. Here, applicable federal law includes superseding federal duties, and that follows directly from this court's decision in Neagle and the rest of the Supremacy Clause defense cases we cite.
Mr. Mills, to be clear, the 11th Circuit is the only circuit that has adopted this particular line of thinking with respect to these kinds of cases. Is that right?
Oh my God.
That's right. No other court has considered it one way or the other.
And how long? Do you know how long this has been the precedent in the 11th Circuit, the application?
That's not
of
a good
supremacy
argument.
clause in this way?
Since 2009.
Thank you.
And in that 15 years, there have only been 3 cases before the 11th Circuit. The Supremacy Clause defense more broadly, the Cobb article we cite in the brief says that since 1787, there have only been 59 cases involving a Supremacy Clause defense. So contrary to the petitioner's argument, this is not a defense that would swamp the FTCA. It simply means that when the federal agents are performing their federal duties, the United States can't be liable in money damages.
Anything further? Justice Alito? Justice Sotomayor? Thank you, counsel.
Oof. Oof.
Rebuttal?
Thank you, Your Honor. I'd like to respond to a few of the questions that came up. With
I
my
thought
friend-
some members of the court were against the death penalty. Holy shit.
Watching him get toasted there. Yeah. So, guys, this is the Institute of Justice lawyer going back up, Patrick Giacomo. So he's in a great spot. He just has to not fumble. He's got to run at the clock.
To be honest, I'd just be like, if there are no further questions, I yield my time. I just sit my ass right back down, to be honest.
Yeah. Well, I think he's got a couple questions he wants to ask or answer. So let's see here. Oh, shoot. Sorry. Sorry. Hold on, chat.
Did you do a dumb?
Yeah, accident. Well, you click the stop sharing button up there. I've done that many a time.
With the court. The first thing I'd like to point out along the lines of what Justice Sotomayor was asking is that the government's position in this case and the 11th Circuit's decision below, their understanding of the discretionary function exception would do 2 things. 1, it would eat up almost all of the entire FTCA, but 2, more importantly, it would certainly eat up all the claims that the proviso was enacted to provide liability for. And here, the language of the proviso itself is very direct, but the Senate report backs that language up. And there, the Senate talked about the fact that what they were doing was removing a barrier to liability, not just a barrier so the rest of the FTCA could then still get in the way, even though the officers had violated the proviso. And so to say that subsection A still applies to bar almost all of, unless you take the government's qualified immunity application, the claims that the proviso raises would mean that Congress has enacted a completely useless law in 1974. That simply can't be the case. Even
have you met Congress?
Of Collinsville, as Justice Jackson asked questions about, or this case, Gaubert doesn't apply. The government gets around this by taking the position that the 11th Circuit has taken, which is to say, unless there is something telling you you can't do this, and the something either has to be a statute or clearly established law, you have discretion. That's not what Gaubert says. There's a whole step 2 to the analysis, which none of the courts in the 11th Circuit or elsewhere that take a broader approach consider. Of course, there's discretion in the colloquial sense when police are raiding a house. But that discretion is not legislative or administrative decision-making grounded in social or economic policy. It's the same discretion we see with driving a car or flying a plane or seizing horses in the Hadley case. And so it simply can't be the
Or
case that
thievery.
what Congress did when it enacted the proviso was to say, even though the officers in this case had a warrant commanding them to go to one address, there was discretion for them to go to another. So they should lose on step one. If we get to step two, there's no question that there was no policy here. As my friend said, the government's policy is to raid the right house. They didn't do that. The preparation is kind of immaterial to the ultimate result here. If you really, really meant to drop the pizza off at the right address, it doesn't matter. You still need to give a refund if you drop it off at the wrong address. Even then, if we look just to the concept of the conflict of the language, we assume that there's a conflict, which again, we do not think the court should do and the court does not need to do. The decision in Alaska is on point with this case. We talk about colons and periods and indentations and the preamble, all of that stuff was available in Alaska. The government was on the wrong side of that case and it made the arguments we're now making, and those arguments prevailed. And in fact, even the dissenting justices cited things that now support us here. Unlike in Alaska, where the proviso was limited to such claims, here we have an affirmative freestanding rule as Justice Scalia requested. And unlike in Alaska, here it doesn't matter that this was in the middle of the set of exceptions, because Alaska was the same way. The submerged lands provision was M, this other provision was E, none of that mattered. What's very clear here from the language Congress enacted and from the fact that it took the time to add this amendment was that they wanted the claims, if they satisfied the proviso, to move forward. And it's crucial to keep in mind that if petitioners win on this issue, they don't win this case. We're fighting to get a day in court where then we can duke it out over the elements of torts and defenses under the Georgia element standard. So it's not as if this case being decided by this court will even render the government liable. We still have more steps to take. But we want to be able to take those steps. And through the law enforcement proviso, Congress said that we should be able to take those steps. Now, on the question about the second question presented in jurisdiction, I can't say whether there's a jurisdictional problem, but what I can tell you is that when we wrote RQP and then saw the government's suggested language for narrowing it, we understood that to mean RQP but narrowed. If it was a completely separate issue that assumed the scope, covered our claims, we would have objected that that was an inappropriate conditional cross petition. But we didn't. And we rightly understood then that when this court did that, it was narrowing our question to the specifics that the government offered, as the government says at page 22 of its bio. That narrowing still requires the court to consider, to some extent, the scope of the discretionary function exception. And if it doesn't, the government's theory, which has prevailed across most of the circuits, that anything that has any element of judgment or choice is good enough to get you into that exception, means that the FTCA will become largely a nullity. This covers cases like the law enforcement proviso cases, but it also covers the more run-of-the-mill cases like VA malpractice, where obviously a doctor has as much discretion to decide which artery to close off than a police officer does which door to go to. Or it will cover.
Thank you.
Thank you.
Mr. Mill.
They're just like, they're like, stop. They're dead.
Stop talking.
They're dead.
Stop talking.
Yeah.
We're
Notice nobody brought up anything. They didn't get in his way.
Nope.
A lot of times it's a sign you're losing, but here they're just like, yeah, you got it. You got it.
Yeah.
Well,
this court appointed you to brief and argue this case as an amicus curiae in support of the judgment below. You have ably discharged that responsibility. The case is submitted.
That gun to the back of your head. You tried real hard. We're pulling it away. Go home. Oh. Yeah. Oh yeah.
Holy shit. I don't know that I don't know that I've heard a beatdown like this at the Supreme Court in quite some time. Wow, I was not prepared. My soul was not prepared for this level of beatdown. Holy shit.
Yes. So
dude.
guys, while the law may have been dry,
shit.
the facts behind it are super important. And then yes, this ass kicking was, I think you're enjoying it a lot more than me, Kurt, and that's okay.
Oh, dude, no. I mean, I'm struggling. The last time I've heard language that this strong, or they're indicating their views this strongly.
Yeah,
I mean, you don't normally get you almost never get this kind of full fat, and you certainly don't normally get it from both sides. You got
Yes.
it from Jackson, and you got it from
Mhm.
Gorsuch. You got it from everyone just
Yes.
slaughtering you in every possible way.
Yes. And you guys, this is big because if the Martins win, people then once again had the Federal Tort Claims Act to sue the police, sue federal agents. It puts another tool back in there. More importantly, what this allows then is, while the Federal Tort Claims Act won't work at the state level, it does show that the Supreme Court has acknowledged, no, you can't, like, the cops can be liable for their misdeeds. So this actually has a lot of far-ranging things. So it's not just the Martins. Like, this is good. Is this going to get rid of qualified immunity? No. But does it allow you to go into court and sue if something happens? Sure. Now you've got Supreme Court precedent in your pocket if this turns out well. Like, how do I think it's going to go? Oh, I think it's probably going to be like 8-1, probably. I mean,
Dude,
Clarence Thomas is...
I could see this case being someday the death of qualified immunity. You know, they send this back 8-1.
Yeah.
The court below does qualified immunity. 11th Circuit does qualified immunity, and they're so pissed, that they just fuck qualified immunity while we're at it too. So I could see this being consequential for a couple areas of law.
Yes.
Every time it goes to the Supreme Court, we just defeat a new doctrine. It's great.
Yes. But for right now, chat, it's just the Supreme Court's going to end up telling them, hey, come back, go back to the lower courts and apply it properly. Bella, would this apply to the man in Kentucky because he was shot over the lawnmower? Yeah, that one too. Like, there's all kinds of police abuses that hopefully start getting addressed. Yes. So yeah. Hey Tyler, how you doing? Tyler from the Libertarian Podcast Review, the best review of Libertarian podcast, but also the best libertarian reviewing podcast. It's like, it depends on how you want to look at it.
Well, this feels like a good case for the Libertarian Podcast to me.
Yes, it does. It does. Ivan Mendoza is potentially uncivil. Well, thank you, Ivan. That's a great idea. or uncivilly criminal. There we go. That could work too. Let's see here.
Potentially civil?
Yes. Bill Thomas says the Institute for Justice is a great group. Yes, it is. Miss Mandy over on Kurt's channel dropping one sub out there. Helping make America green again, chat. John and Jane Doe for £5 sterling, the Kings sterling, says for Kurt, payment for the laborious task of actually reading a TOS and sending a single email. Hey, doing lawyer stuff. So
yeah.
Reading.
Reading
Barb
is good.
K. Yeah. Barb K with the $5 sticker. Robert Lawrence gifting 5 subs. Bushmaster says, did the DOJ not send their best? It doesn't matter who they were going to send. You could have had Paul Clement up there. There's only so much you're going to be able to do. Sometimes the turd is a turd no matter how much you polish it.
Yeah. I'm sure that guy tried his best, but
yeah,
Yeah,
nobody goes up there with the intent of getting your ass kicked. That just looks bad, and since the Supreme Court, it'd be embarrassing. Yeah. So nobody goes up there going to take a dive. Michael Gelke for 100,000 dong. Just globetrotting all over Southeast Asia. Says the U.S. government is worse at appealing decisions to dissent than Iraqis. GG, no re. LPR says, my wife tries the same tactic of assigning an advocate for her losing arguments. Yes. Hopefully your wife's not watching, Tyler. Barb K with another super sticker. And then Barb K for 10 uncivil law memberships.
Always appreciate it. Thank you, Barb. Barb's been giving quite a few memberships lately, so that's very much appreciated.
Yeah, Barb, thank you for the support and your generosity. And if you guys got one, make sure you tell Barb, Donka. Cyanide Cologne says, I heard Carl Jobst might be looking for extra money. Maybe he can go back to being a dating coach. Yeah. Did you hear about his case? He's the he defamed the King of Kong guy, Billy Mitchell.
Mm-hmm.
And the court
Australia.
Was like, yeah, court's like, nah, mate, you defamed him completely.
Yeah,
and you're 100%.
He made statements that were, I forget what they weren't, but they weren't about his video game cheating.
No, it was about him allegedly. He said that Billy Mitchell had caused the guy to commit suicide, And court's like, yeah, you can't do that. And yeah, they're like, no, you were such an asshole at trial. Like, I'm even finding you more responsible. I'm punishing you more.
Cool.
Amateur Iconoclast says, wait, which one's Jimmy and which one is Chuck?
Between the two of us? That's a good question. What do you think?
Well, I don't know. Because I'm not. I have a confession. I've never watched Better Call Saul.
Okay.
I just know the guy doesn't like electricity for some reason.
I recommend it. It was a good show.
Yeah, I guess. Like, I'm just worried I'm going to sit there and watch it and be like, no, that's not real. Or I'm like, oh my God, I wish it was actually that real. So I don't know. Stephen Cooper says having a creative writing degree and not being able to read. That would be rad. That'd be the definition of ironic.
Which he would know the definition of if he had a creative writing.
If he could read, yes. If only he could read.
Yeah.
So what's the LPR saying? What's the preliminary take on Bondi's decree to entering houses without a warrant, considering SCOTUS' take on the Fourth Amendment here? Bondi's an idiot. They don't have any authority just to go into houses. Even if you have an arrest warrant, you still need a warrant to go into a home. You can't
with an arrest warrant. You can.
Sorry, yes, but they don't have any warrants. They can't just go in and get people. Even if you know the person's illegal, you can't go in and get them. You have to have proper process to go after them. So I don't know. Pam Bondi says a lot of dumb shit. So
I mean, there is an interesting case to be had relating to the scope of the constitutional protections when it comes to people who are not here legally, and there's not much case law on it. Kim Van Ark talks about rights for green card holders or permanent residents because
Plyer v. Doe talks about non-residents.
Yeah,
that's about kids. Kids of illegals getting proper schooling. So, I mean, if they're entitled to school resources, they're going to be entitled probably to supreme, constitutional things.
It's an interesting argument to be had. I mean, I suppose on first principles, yeah. Same incidentally, it's like First Amendment protections, actually for just constitutional protections in general, the scope of constitutional protections for people who are not here illegally is an interesting grounds. Also, of course, birthright citizenship, also still an interesting issue. More interesting than I initially gave it credit for. So
yes, as I say all these things, no, they need a warrant. You can see Trump leaning over my shoulder, like, is that what you really think? It's like, yes, it is, Donnie. Barb K says, new subscriber here. Well, thank you for joining here, Barb. I appreciate it. I would say Uncivil Law sent me, but that wouldn't be totally true.
I would never send anyone to potentially criminal.
Oh, let's see.
I like people.
Yes, Robert's saying they should have no right to school either, but that's but the Supreme Court settled that 40 years ago. So, yeah. Roscoe Coltrane says we only have the highest Denny's jokes in chat here. Pam Bondi and Kash Patel have yet to impress. Very true. Very, very true.
Yeah.
And then somebody's saying, does Kurt have a dinosaur in the background?
No.
I don't know. I don't know what they're looking at. I see your bee.
I got a tiger. I got an Eeyore. I got a bee. I'm not sure what kind of dinosaur you're looking for.
Yeah. There was something on your screen where it's changing.
Yeah, that's when OBS I get an alert. I think that's for new Facebook subscribers
okay.
Because I never bothered to change the alert for Facebook subscribers. So I think when the dinosaur comes on screen on OBS, it's for a new Facebook subscriber.
EDW Raptor says I was promised pizza casserole. Well, sorry.
Pizza casserole solid, man.
I know it sounds good. Good.
Bato
says this is Ohio. We have gross spaghetti and first watch. Denny's can get lost. Well, yeah, but Skyline Chili is not anything to be proud of. So America Dreamer says my dog stepped on Kurt's bee. Well, Kurt, I think this is going to be one of those ones where the Supreme Court's like, Lamau, fix this. You guys need to fix it. And I wonder if the court's actually going to be able to do it. I don't know if they're going to understand the assignment, but I can see it coming back on, because remember, The qualified immunity issue, we haven't even gotten to that. This is the issue of, are you even allowed to have a lawsuit? And if you're allowed to have a lawsuit, then what can you do? So there's still a lot to this case, and this is just merely getting in the door and having the standing to sue, really, is how you need to look at this.
All right, cool.
So,
well, thank you for having me for this fun
Yeah.
day. Just a reminder to my chat, I'll be on later today with Aussie Insider relating to Karen Reed. We're going to have a nice little discussion later today. That's supposed to happen, I believe, in 2 hours on my channel. So make sure to check that out. Should be fun.
2
Have fun
hours?
talking about, yeah.
Okay, that should be fun. So 5 o'clock Eastern.
Yeah.
All right, guys.
So
see Kurt over there.
I recommend checking that out. Should be a lot. Should have a good time, and make sure to hit the like button and do all those YouTubey things because it helps with the channel and channel growth.
Yes. Well, thank you for being here, Kurt. I appreciate it. It's always good to
Yeah.
see you, man.
You're the best, man.
All right, take care.
All right, bye-bye.
Yep, bye. And then Barb K with another super sticker over in Kurt's thing. Yes, eat Skyline if you want diarrhea. Yeah, it's just awful. It's just awful. So, anyways, guys, yeah, so this is the thing. It took 8 years to get to the Supreme Court. This is going to go back down to the lower courts, and it's going to be even more years. These people might have to wait 15 years before, like, and let's say it comes back to the Supreme Court again. You're looking like 15, 20 years to settle one legal case. Think about how fucking crazy that is. But that is the problem. Like, the wheels of justice, they turn slowly. But when they grind, they will grind whatever grist is in the way. So, yeah, Elisa Marie says that's ridiculous. Yeah, but that civil stuff is really slow. It's really slow. You're waiting there. You're not watching an uncivil live stream where Kurt is gone. Well, we're going to finish up here in a second. Yes, and Luke is right. There is a case. There's a property dispute involving wetlands. Has been in the SCOTUS twice in over a 2-decade-long lawsuit. Yep. There are some things that have issues like that. And somebody said, are we going to do a model stream tonight? Yes. But Chad, if you are interested in hanging out with what I'm going to do later tonight at about probably going to start about 6 o'clock. We are going to go through Turtle Boy's appellate, or is not appellate hearing, but his bond hearing. I think it's very interesting to break it down, see what's going on. The court hearing he just had and the arguments made during it. I do think it's very good to watch and take a look at. So that'll be at 6 o'clock. I'm going to set the stream up for that in a second here. Haven't gotten it set up yet. Then after that, chat, we are going to do some models tonight. We're going to do some more painting tonight. We got a whole cup of Wehrmacht guys to paint up, so we'll work on finishing up our miniatures. Golden Mungo says that's what we call a speedy trial. Yes. And then EDW Raptor gifting 10 subs. That's right, chat. 10 subs. Grace, keep moving. This is a green neighborhood. And Barb K is a new member. Thank you, Barb. Thank you. Thank you so much. Thank you so very much. Botto Entertainment says, so guys on Court Listener and Pacer, any word on the Greer Zoom link? I can't find anything. Well, if you guys can't find it, you can always call the court in Utah and see if it's available. If it is, they will send you the link and the information for it. If you guys are going to go to the Russell Greer hearing, don't be dickheads. Please don't do that. You'll make it worse for everybody. Just go and behave. Be a good boy. Be a good boy, chat. Be the good boy I know you could be out there. So let's see here. What else we got? Kurt says, my stream has been hijacked. Trakisha McNeil says, yeah, they want him in jail. They want Turtle Boy in jail so badly. Yes, they do. Yes, they do. 100% they do. So, Fair Frozen said you had a Zaku. Do you know what scale it is? I'm guessing on 1/100th, or they get you on 1/60th. I don't know. Let me you're gonna have to, if you go back through my shows and you look through the model streams, you should find the thing, because when I do the models, I always just take a picture of the box and make that the cover. So yeah. Patty says Washington just made a law that says priests must violate the seal of confession. You should cover that. I will. That's interesting. Send me some information on that. Alex says, "Oh, I figured you were joking. It's okay, man. I know you're joking. It's all good. Be like Clyde, yes." Alex says, "I'm not a good boy." Well, then just don't be a tard in court. It's 1/144th. Okay. Katie says, "Where's Kurt?" Kurt had to take off. He's getting ready for his other stream coming up. He's going to be on with Aussie Insider, covering Kieran Reed in about 2 hours. Iman Razu says T. Oh. I better bring some tampons for the Boston cops tonight. Yes. Can we build towers in the Zoom chat? I would rather you guys not do that. Do not do that, please. So yeah, do not do that. Do not do that. No, guys, Aussie Insider is not Aussie Overlord. Those are different people. So it's not Hayden. Although Hayden is also a great friend of the show. And while you're here, guys, real quick, wanted to get to our sponsor tonight. It is the dragonstreasure.com. It's a haven for tea and anime lovers. But also, really, if you guys like coffee, Dragon's Treasure sells some really good coffee. He sells some really good soaps as well. Just don't combine all the products. It'll probably be kind of nasty, especially if you try to drink it. But you can get your coffee, you can get your tea, you can get your soaps. Use the promo code criminal and you get 10% off. Guys, I know this is a thing there. Mentioned before, I've been talking with T-Man. It's been having a little bit of a rough patch out there financially. So, guys, please, whatever you do, buy from him, show him some love. I would appreciate. And I also told T-Man, whatever, obviously, if there's a coupon code, he's sponsoring me. I told him whatever I'm supposed to get off that coupon code, he needs to keep for himself. We'll settle up down the road later when things are better. So if you guys really want to help T-Man out, definitely hit him up there. And definitely take care of T-Man. He would really appreciate it. Then the other sponsor for today is MAF Corporation chat. That's right. MAF Corporation, MAF-arms.com. Use the promo code POCRIM, 10% off all of your wind chimes and accessories. Remember, chat, when you use the promo code POCRIM, put in the comment lines that you want a kiss from Matt, and Matt will, get some lipstick on, and he'll kiss your invoice with an XOXO. And remember, chat, over $500, Ivan, the spitting rat, will do it as well. Yes. Go buy some stuff from the T-Man. Yes. Go buy some stuff from the T-Man. He needs it. Help him out. Show him some love. Mr. Squiggles, he's been a member for 31 months. Wow. Man, you've been here for a while. And I appreciate it, Mr. Squiggles. It's good to see you, by the way. Changed up your avatar, too. But thank you for being here. And it's Clyde. That's never a bad thing to put down. Rip C. Goody. Guys, that's the thing. I do feel bad. I feel it's sad that he passed away. And, I hope he, sorry for whatever he's going through is, it sounds like whatever pain or whatever it is, hopefully it's over now. Hopefully his family has some closure. So, Kurt needs a meme coin. Oh, it's Mr. Squiggles is my dad. No, my dad wouldn't be that clever. I don't think my dad would be able to stay on top of 31 months of doing memberships. So, yeah, you guys apparently see Goody did pass away. So, looks like that's official. If it did, very sorry to hear about it. Rip, man, and while we may have had our differences, I hope you're at peace now. So, get off the graces, I believe, pot crim. Yes. Here's a question. Might you stream the court call on Tuesday? No. Number one, I don't think I have permission to do that. Number two, I am going to be dealing with lawyer shit. So no, I can't. I don't have the time. I will not be able to do that. So no, I will not be able to. Be happy to cover it afterwards. How did he pass away, guys? I don't know. It's not clear in any of the documents available. But like I said, whatever it was, sorry to hear he passed. And yeah, hope You know, if he was in pain, I hope that, you know, I'm sorry to hear that that caused it. And if he wasn't, it was just untimely, you know, it's sad to hear. So, yeah, I'm sorry, I'm not going to be able to cover it. So, but with that said, chat, we'll be getting ready to go on. Like I said, we'll be on at 6, and yeah, we'll be covering Turtle Boy. Should be very interesting. I have not listened to the hearing yet, but it's pretty good, and we'll be going from there. So, I will see you guys next time, and just remember, just because you did it does not mean you're guilty. Does not. That means all of you out there, chat, you're still not guilty. Now, if you're the feds and you're kicking in people's doors wrongly, yeah, you probably are a little bit guilty. So, just a little bit. So, with that said, chat, I will talk to you guys later. Take care, and I'll see you guys. Remember, 6 p.m. We'll be going over Turtle Boy stuff. Good night, chat. See you then.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when...
Okay, nap sounds really good right now, especially because it's like all rainy and crappy here. Nap sounds real good.
When they nab you on illegal stops, just cause you did it doesn't mean you're guilty. But please talk to a local attorney.
EDW Raptor with 5 more subs. Thank you for the support. I appreciate it, man. Thank you for the support and your generosity. Please, chat, tell him thank you if you received one. I promised the guys, I promised to read them, so we're still out, and I have to do it.
Was that the fat guy Rick hated yelled at? Why, yes, it was. He even knows he's fat. For all this fun and more, there's one place to go. Here on Sean Martin's Potentially Criminal Show.
Dolly talks, squeezing in right at the end. Dolly, hope you're doing well, man. I didn't get a chance to talk to you when we were on Nick's stream, but hope you're doing good out there, buddy. Gifted 1 sub. Thank you, Dolly.